Other hearing, one another.
Your Lordship, please. May it please, Your Lordship. Lords, I had stopped at a reading of the division bench of the order of the division bench of the Kerala High Court. In the case of High Court of Kerala versus Mohandas PK, which has been relied upon by her ladyship while allowing the writ appeals. Please see para 3 of that judgment notes. The facts are not in dispute and lie within a very narrow compass.
Compilation, Kerala. No, judgment compilation. (2017)
Please,
Yes.
para 3, my lords. The facts are not in dispute and lie within a very narrow compass. It appears that the question of fixing of the cadre strength of the cadre of the Kerala State Higher Judicial Service, that is district judges cadre, was a matter which was considered by the High Court in the administrative side, and a recommendation was made to the state government. The High Court had identified and requested that the cadre strength of district judges be considered and notified as 146. The state considered the same, but it notified only 130 instead of 146, mentioning that out of 146 posts identified, 7 are deputation posts and 9 are of family courts, which are manned by retired district judges. Hence, these 16 posts were excluded. The GO dated 29/5/2015 was challenged before this court, and a learned single judge of this court, by judgment dated so and so, disapproved the government notification on the ground that no reasons were indicated for rejecting the 16 posts as aforesaid, whereby the proposed cadre strength was brought down from 146 to 130. It seems thereafter there were discussions as between the state government and the High Court on the administrative side. The state government then, in consultation with the High Court, thought it better to provide the definition of cadre with cadre strength. Accordingly, the notification was issued by the state government on so and so, wherein the definition of cadre strength was given as under: cadre strength shall constitute all the sanctioned posts of the district and session judges, all the sanctioned posts of judges in the equivalent stature, all such temporary posts existing for more than 6 months, and all such posts created by the government from time to time in the Kerala State Higher Judicial Service. Having defined the cadre strength in the terms aforesaid, the state left the numerical strength to be computed by the High Court. Pursuant to this notification of the state government, the High Court calculated and notified the cadre strength on the basis of definition aforesaid as 169. The moment this was done, the judicial officers of the subordinate judiciary of this court, through their associations, filed representation to the High Court and thereafter instituted the writ petition. The grievance, which is the same question as far as temporary posts here is concerned, was that temporary posts and posts of which judicial officers were deputed should not be calculated and taken in the cadre. Their submission was the temporary post cannot be included in a permanent cadre, and secondly, that fixing cadre strength is the duty of the state and not of the High Court. The learned single judge heard the matter and allowed the writ on both counts. Lordships may skip para 6 and please come to 7. We have heard the parties, and in our view, the appeals are to be allowed. But before we proceed, we would like to notice an important fact. We are indeed surprised as to what was the prejudice that was caused to the judicial officers by increase in cadre strength. Mallards, I pause here for a moment. This is one of the reasons that Her Ladyship has assigned to allow the appeal, that the direct appointees must be first and foremost be able to show what is the prejudice caused to them. Even if there is an expanded pool in the cadre by whatever interpretation, taking temporary, fast track, etc., the cause of action for the writ petition must be some prejudice to persons appointed from that set of district direct appointees.
Correct, but the observation appears to be made in the context of a rule of a notification which provided what would constitute the cadre.
The cadre, yes.
But that appears to be absent in.
It is silent. And I will next, I'm grateful for the question. Next, take your lordships to Ganesh Rao's case of the Honorable Supreme Court, where their lordships have held that unless there is an exclusion, all posts, including temporary, would be treated as being included in the cadre. So, this is the first part, my lords, para 7. We are indeed surprised as to what was the prejudice that was caused to the judicial officers by increase of cadre strength. Earlier, the cadre strength of the district and session judges was 130. That being increased to 169, a virtual increase by 40 posts. Therefore, the number of posts available for the promotees would substantially go up. If that be so, then what prejudice was being caused to them to file these writ petitions, and why was it entertained? We raised this issue at the bar. There was no satisfactory explanation as to how the subordinate judiciary was adversely affected. If any, their chances of promotion only increased. To us, it appears that there was a grievance in a different way. The temporary posts or posts which are normally considered outside the cadre are posts in which the direct recruitees are not normally posted. In practice, it is the sub-judges who get ad hoc promotions to these posts. By including those posts into the cadre, those posts would now be available to all those in the cadre, taking it out from the exclusive privilege of the ad hoc promotees. To us, this is not a genuine grievance. On this count alone, we think that the writ petitions showing no valid cause of action ought to have been dismissed. Further, as the learned single judge has entertained and decided the same, we think it appropriate to deal with the three issues as decided by the learned single judge. So, my lords, the merits aspect also are gone into. Lordships can ignore para 9, which was on the aspect of reconsideration on the facts there in para 10. The second ground taken was that temporary posts cannot be included in the permanent cadre. The learned single judge upheld the said contention. Respectfully, we think that this is a wrong proposition of law. A cadre is a designated group of officers who are grouped together. Cadre means strength of a service or part of a service sanctioned as an independent unit. It may have posts of different grades. It may even include temporary posts, work charge posts, supernumerary posts, shadow posts created in different grades to constitute cadre. That is the prerogative of the state. In this connection, we would refer to judgments of the Supreme Court, then Baleshwar, Pushparani, etc. are referred. The learned single judge was clearly wrong in holding that temporary posts could not be included in the cadre. Lastly, the single judge was of the view, and this is on the Article 233 aspect, my lords, which also her ladyship has upheld. The learned judge was of the view that the power of declaring the cadre strength was that of the state, and the state could not have delegated it to the High Court, in the sense left it to the High Court to quantify the same. The learned single judge was of the opinion that not only the post but the numerical strength have to be declared by the state. We are unable to accept the same. It is for the state, in consultation with the High Court, to declare the cadre and its strength. Its strength is to be calculated on the basis of the posts which are brought in the cadre. Once posts are indicated, then it is only ministerial work that is required to be done by the High Court. In fact, notes, I'll go one step ahead. It is not simplicity or ministerial. Under Article 233, my lords, Bal Mukund Shah and other judgments have held that it is, my lords, an independent power constitutionally bestowed in the High Courts under Article 233. So, in a sense, this judgment treats the work as ministerial. I would, on that point, slightly differ with their lordships, because it's more than ministerial. It is part of, my lords, administration of justice. And finally, my lords, at para 13, before closing, we would further observe that once these 169 posts have been taken into account by the High Court for the purpose of declaring the cadre strength, the High Court would now be required to post people from the cadre on the said posts. The list of posts within the cadre on the basis of which the committee of the High Court has fixed the strength has been placed on record. Let that form part of this judgment as well. This judgment, my lords, was relied upon by her ladyship, and for the sake of completion, I may tell your lordships that this has been carried to the Honorable Supreme Court. Leave has been granted, but there is no stay of this judgment. I have placed, my lords, the entire set of proceedings. That's okay. Go to Ganesh. Yeah, my lords, the second page is an order dated 10/11/2017. Leave granted. Issue notice on prayer for interim relief. But thereafter, if your lordships see, there has been, my lords, adjournment of the matter from time to time. No interim order pressed or granted, and ultimately the last page, which is the last order, my lords, of 31/7/2018, when the matter was directed to be listed next week, but it's now been, my lords, over 7 years since the case has come up.
The stakeholders have spent themselves.
Looks like it.
Yes.
So, my lords, I am now going to respond to my lord's question on the prescription in the rule. And please now see the judgment of the Honorable Supreme Court, and all cases that I'm citing, my lords, if your lordships permit, I will take back at the end and make a compilation and then file it.
You are notings.
Oh, yes.
That's okay. It's okay. If we will
I will not be burdening your lordships with too many judgments. Yes, we'll make an index for your lordships.
Yes.
Great,
Let them make index and serve a copy on us so that Lord will,
of course.
before relying upon.
Copy code. This is, my lords, the judgment in Ganesh Rao. Now, please come to para 3 first, my lords. It sets out the contours of the matter. Around the same time, the High Court also recommended names of 23 subordinate judges, including R4 to 11 in the present appeal, promotion to the temporary posts of additional district and sessions judges. The state government did not take immediate steps to issue the appointment orders in favor of the persons whose names had been recommended by the High Court. At the time when the advertisement was issued in the year 1989, the total number of permanent and temporary posts of additional district and sessions judges was 251. Then, my lords, those facts I need not really trouble your lordships with, and take this honorable court to para 10. Before dealing with the main issue raised in the appeal, namely the inter se seniority of direct recruits and the promotees, the first and foremost question which requires consideration is whether, for calculating the one-third quota of direct recruits as provided in Rule 6, the temporary posts of additional district and session judges have to be included or not. Rule 6 only says that of the posts in the cadre of the service, two-thirds shall be filled by promotion and one-third by direct recruitment. Cadre is defined in sub-rule A of Rule 2, and it means the cadre of the Bihar Superior Judicial Service. It is important to note here, kindly mark this, my lords, that the definition of cadre as given in the aforesaid rule does not say that temporary posts have not to be taken into consideration or have to be excluded, nor is there indication to that effect. Cadre means the entire cadre of the Bihar Superior Judicial Service, and therefore there is no warrant for excluding the temporary posts. And this rule, my lords, is pari materia with Rule 8.7, which was considered by their lordships, my lords, in the writ appeal. And on this point, my lords, the last authority that I cite, just for completion, my lords, is a division bench judgment of the Rajasthan High Court. I'm just placing it, my lords, because it reiterates the same position, but it has, my lords, an exhaustive discussion on all judgments on the point. This is 2001 1 Rajasthan Law Weekly, page 320. Para 15 onwards, your lordships may just kindly note. Yes. If your lordships permit, I'll just read 15, my lords. From the aforesaid decisions, it is well settled that ordinarily, unless the rules otherwise provide, the cadre strength of the service for the purpose of operating quota rule and determining the vacancies available to be filled by different sources, the permanent as well as temporary posts or any other post created in addition to the permanent posts under the service rules constitute the cadre sense of the service against which appointment by regular mode can be made. And ordinarily, the quota rule operates against the total strength of the cadre, including temporary and as well as permanent posts. Now, my lords, may I now return to the judgment of her ladyship allowing the appeal. I had read para 41 to your lordships. Please, lords. Before 41, if your lordships would just want to see that rule once again, which was extracted at para 39, to see that there is no exclusion, because the Rajasthan High Court has also held that unless there is exclusion, it is all inclusive. And 8(7) is extracted. Cadre means the strength of a service or part of a service sanctioned as a separate unit. So it is a broad definition. Now, my lords, I read 41.
Sorry, just
Says cadre. Page is 82. Internal page. This rule applies. This service rules. Depends cadre on it. This is strength or a part of service. Part of service. This is separate.
yes.
Please, my lords. 41, my lords, refers to the judgment of the Kerala High Court. I'll skip that where it is extracted. Then 42 onwards, the learned senior counsel appearing for the respondents has placed on record a compendium of all the service rules with regard to recruitment of district judges from 1962 onwards. Those extracts your lordships get at para 40.
Just 1 minute, just 1 minute.
Please.
Rule 8(7) says cadre means the strength of a service or part of a service sanctioned as a separate unit. What is the term sanctioned? Now one interpretation which perhaps you would say is the definition itself says cadre means strength of a service or part of a service. Now sanctioned, what is this connotation of the word sanctioned as a separate unit?
That would have to be read in the context of the second part of the definition, my lords, which is part of a service sanctioned as a separate unit. So if in a given case, illustratively, there is a sanction order, treating a part of the service, my lords, as a separate unit for the purpose of service in a department, then, my lords, this portion would be attracted, because otherwise the phrase separate unit would really have no meaning. The earlier part of cadre is the strength of the service, which is all encompassing. But if it is a part of a service sanctioned as a separate unit, then it is to be treated as a standalone cadre. That question, of course, may be academic here, but the point I was trying to make is, this is not an exclusionary definition. It does not exclude a temporary post.
So perhaps now suppose you have district judges, you have super time,
Quite
etc.
so.
So you are saying in the event the rule said that out of the district judges, so and so have put in service more than this,
Lordships.
will be selection grade.
Please.
So and so this above this would be super time. So that would be the second part.
That's the second part of it. I'm great.
So the first part, according to you, merely defines cadre means strength of a service.
Please.
So literally taken, whether it's temporary or otherwise,
Lordships.
at the relevant point of time, what is the strength of the service at that point of time?
Grateful.
When you are doing promotion. etc.
I'm so grateful. And that is in keeping with the interpretation, my lords, in Ganesh Rao Patnaik and the view of the Kerala High Court. I'm conscious that in Kerala, the rule was more explicit. And maybe again, your lordships, as I submitted earlier, dehorse the matter, would like to revisit the rules, my lords, applicable to the state under 233, maybe make the rule more explanatory or otherwise. That's your lordship's discretion in the administrative side, because those powers are constitutional. The state really can have no say there directly. But notwithstanding that, the rules as framed and applicable are broad enough to cover these posts. And keeping this, my lords, in mind, her ladyship referred to the Kerala judgment. Then para 42 onwards, all the rules are extracted, which I will not trouble the Honorable Court with once again, and take the Honorable Bench to para 46. It is therefore clear.
I'm only expressing a view. I'm only expressing a view.
My lords, we're grateful. Your lordship's questions help us
Yes.
respond. In fact, I don't think it's a view even, my lords. It's your lordship's question to the bar. It is therefore clear that rules relating to reservation and appointment are made applicable to recruitments under the Karnataka Judicial Services as well. However, since the specific rules which are made applicable are specified in the judicial service recruitment themselves, reliance on the rules which are specifically not applicable, circulars and government orders rendered on the basis of those rules, which provided for applying the quota against the arising vacancies, are not applicable to the appointment to the post of district judges. It is clear that such appointment is primarily governed by Articles 233, 234, and 235 of the Constitution and judicial services recruitment rules, which are in force at the relevant time. It is pertinent to note here that some recruitment rules governing fixation of seniority provide for the fixation of cadre strength by the governor or the government specifically. However, this is also not the case in the instant rules, since there is no such provision that the cadre strength has to be fixed by the government. Therefore, the decision of the apex court in the case of High Court of Judication of Rajasthan versus Veena Verma would also not be applicable to the facts of this case, since the Rajasthan rules specifically provided power to the government from time to time in consultation with the High Court to vary the cadre strength in judicial posts. In the absence of such a provision in the rules that are under consideration in the instant case, it was open to the High Court to fix the cadre strength on the basis of the notifications issued by the government. Further, it is also clear that the recruitment rules do not specify the fixed numerical cadre strength for the posts of district judges. Therefore, the cadre strength would include all those sanctioned posts in the cadre of district judges and all posts which are to be manned by officers in the cadre of district judges. Then, my lords, the requirement of a separate specific notification by the state government is also rejected. Then at para 48, her ladyship deals with annexure N, which was the list. I may read this. A perusal of annexure N dated so and so would show that the list starts at serial number 38 and takes into account all persons who have entered the service since 7/3/1983 and who have been promoted as district judges with effect from 26/5/2003. Lords, these dates would be relevant because after this I will be citing the judgment of the division bench, Her Ladyship Justice Nagratna's view, which actually, my lords, concludes the other question on which his lordship dismissed the appeal and deferred, which was the question of FTC, the fast track courts. A lot of those, my lords, appointments took place thereafter, after this 2003. And in that judgment, one of the paragraphs says that, look, many of those persons may have well retired by now, and therefore the list can be reworked at their back. I must not make one submission here that this batch of promotees does not fall under either of these categories, that is temporary or fast track. I tie that up with my earlier submission that the writ petitioners ought to have shown some prejudice. The reason for the learned judge who dismissed the appeal and deferred from her ladyship was this twofold broad aspect. One was the temporary post, which I have covered, which is in the teeth of the view of the Honorable Supreme Court and Kerala High Court, and the fast track cases. Now, first and foremost, my lord, these respondents who are the beneficiaries of the promotion in the seniority list do not fall under either. And secondly, the question of fast track courts is covered, my lords, as far as this Honorable High Court is concerned, by the earlier division bench judgment. A learned single judge is now practically the view of a learned single judge, even though it is in division bench because there is a difference of opinion. The bench itself could not have differed. Had the division bench differed from the earlier view, my lords, in respect of fast track courts, then the matter would have to be referred to your lordships as a larger bench. That has not happened. Her ladyship has in fact followed that view. And your lordships would then test whether the differing opinion could have, my lords, virtually sat in appeal over the division bench judgment on the question of fast track courts and held that yes, we need to rework the list. Those persons have since retired and therefore let us carry it out. I will show your lordships that exact reasoning. So, my lords, this para 48 basis annexure N, which was placed by the High Court on the administrative side, shows that promotions are as of 2003. Yes. Mm. Don't go back now. Technically later. So, Manoj, this then sets out what the High Court had placed. I need not read it all because the Lordships have seen it. Now comes para 49, which is again in keeping with the view of the Kerala High Court on locus really. The only point on which a challenge can be raised by the directly recruited district judges is with regard to the promotees exceeding their quota. In case there are no such promotions in excess of the quota applied as against the cadre strength, the direct recruits would have no claim as against the promotee district judges. In the instant case, a perusal of annexure N final seniority list would show that the seniority of the promotee district judges was fixed by reckoning their seniority from the date when they were appointed to substantive vacancies and not from the date of their appointment as fast track court judges. Now, I just pause here. This principle that the promotee district judges seniority was fixed by reckoning their seniority from the date when they were appointed to substantive vacancies and not from the date of their appointment as fast track court judges is the precise ratio in the earlier division bench judgment. It is pertinent to note that the specific dates on which the private respondents in the writ petition have been appointed are stated in annexure and seniority list. It is worth mentioning that apart from stating that the promotees are in excess of the quota fixed against the cadre strength, the writ petitioners do not have a consistent case as to how many of the promotee officers are in excess of the quota as applied cadre strength. Further, the contention appears to be that several of the posts which are included by the High Court in the cadre strength are not posts which are permanent in nature, and therefore those posts could not have been included in the cadre strength. The details of the posts which have been included in the cadre strength having been made available, there is a further contention raised that the cadre strength should be declared separately and specifically. It is not possible to accept these contentions. Once it is accepted that posts of district judges have been created, or that posts have been created which are as matter of fact being manned by district judges, then the contention that specific notifications of cadre strength have not been effected cannot stand in the way of promotions being made to the quota as applied against the cadre strength. It is only if the petitioners can specifically point out, please mark this, my lords, that the promoted district judges are occupying posts which are meant to be filled up by direct recruitment, that they could have succeeded in the writ petition filed by them. And it's my very respectful submission that neither before the learned single judge nor, my lords, in the writ appeal did the original writ petitioners make this aspect good. Then, my lords, I will skip 53, etc., and then take your lordships to the final order, my lords, at 56. That is, having considered the contentions advanced, etc., it is clear that the finding of the learned single judge at paras 33 and 34 under appeal requires interference, accordingly allowed. Now, my lords, on the question of fast track courts, which is the second.
Just before that, let's assume that their contention that the proportion of, as per the rule of promotees versus direct recruits is violated. Let's assume for a moment.
Please.
And the court was then to order. Theoretically, what would be the process? Either you're going to redo it or merely say that for the future promotions, you adjust this mismatch by asking one branch to forego. That you just keep in mind that let's come finally, let's come to a position where we are going to decide. Just keep in mind, you need not respond now. So if we were to, if they were to make out a case that the post occupied by the promotees was in excess of their proportion, then the legal consequences, whether you have to push down or you have to say
Adjust.
that in future,
Yes.
you just forego it. Just keep that in.
I'll my lords, keep that in mind and respond at an appropriate stage. Yes. Yes. Now, my lords, Sir Ladyship.
known later, but in future we follow Maharashtra.
Yes, yeah, page 50. Isn't it page 5? Hmm? 40, no, sir.
Yes.
Please, Manoj.
Law of the land is not, they can't be adjusted. What Supreme Court says is, they will push down, data will be postponed. Nobody will revert. No adjustment. Quota should be maintained each block. For excess is there, they will push down to next block. Data will be postponed. That is what the law in Gujarat was not consistently held. Karnataka is concerned. And division bench also says yes.
Yes.
I'll answer your lordship's question later. Now, my lords, I was on this aspect of the fast track court judges, and if your lordships just come to para 21, where the High Court had argued, para 21 over the page, my lords, the fifth line, insofar as seniority assigned to fast track court judges, the same has already been determined in Writ Appeal 6514 of 2013 and connected cases. The issue pertains to the years prior to 2010, and the writ petitioners who were appointed in the year 2016 cannot be permitted to re-agitate this issue. Please mark this, lords. None of the affected fast-track court judges were made as parties to the writ petition, and they have all retired to writ prior to the writ or publication of the seniority list. The writ petitioners do not have locus standi to question the seniority of fast-track judges under 65% promotional quota, as sufficient vacancies existed under 65% quota when respondents 13 to 82 were promoted. This question also did not arise. Now, this takes me to the judgment in the writ appeal itself, which your lordships have seen, but at the cost of repetition, please permit me to just refer to some paragraphs, which is at page 234 of the papers. Though the judgment, my lords, in extenso deals with the law on the point from para 73 onwards, and I won't read this entire judgment, lordships have already seen it. 73A, my lords, Bridge Mohan Lal 1 is referred.
Volume.
294.
First volume, my lords.
But volume 2, Lord. Volume 2.
Sorry, I'm so sorry.
Volume 2.
I'm so sorry.
It commences from 234.
Volume 2, 73, my lords, at printed 375.
It's not 375. Volume,
We would, lordships have it. We would summarize the ratio of judgments of the Honorable Supreme Court as follows. In Bridge Mohanlal 1, and this is a bench of 3 learned judges of the Honorable Supreme Court, Honorable Supreme Court categorically held that while making appointments to FTCs, the first preference must be given to those eligible judicial officers who could be given ad hoc promotions, and that while giving such promotions, high courts had to follow procedures in force in the matter of promotion to such posts in superior higher judicial services. The recommendation for selections or ad hoc promotions was to be made by a committee of at least 3 judges of the High Court constituted by the Chief Justice. The final decision in the matter was to be taken by the full court. After ad hoc promotions of judicial officers to FTCs, the consequential vacancies were to be filled up immediately. Thus, while making ad hoc promotions of judges to FTCs, the extant procedures in the matter of promotions were to be followed. So this is, my lords, the law in Bridgemohan Lal 1. Then, my lords, the judgment at 376 considers one other observation in Bridgemohan Lal, which is the second unnumbered paragraph therein, to hold. Of course, the Honorable Supreme Court also observed that there was no right conferred on a judicial officer to claim regular promotion on the basis of his or her appointment on ad hoc basis under the FTC scheme, as service rendered in the FTC was to be deemed as services rendered in the parent cadre. It was also stated that if any judicial officer was promoted to a higher grade in the parent cadre during his tenure, service rendered in the FTCs was to be deemed as service in such higher grade. These observations have been relied upon by the petitioner's direct recruits to contend that ad hoc promotions did not imply grant of regular promotions to respondent officers. The Honorable Supreme Court also opined that as far as service conditions are concerned, ad hoc promotees were to be governed by rules and regulations which were applicable to members of judicial services in the cadre of district judges. So this latter observation in Bridgemohan Lal 1 was considered by the division bench, and I will take your lordships to how it was finally adjudicated. Meanwhile, lordships may just mark in B, my lords, Bridgemohan 2, which is of 2 learned judges, is referred, that is 2012. Then, my lords, Madhumita Das, please skip that. Para D at 379, the Debabrata Das judgment, also 3 judges, also 3 learned judges, which refers to Bridgemohan 1 and applies the same, which lordships can just mark at page 380, the 4th line. Thus, what follows from Debabrata Das is that the period of service rendered in FTC could be deemed to be service rendered in the Superior Judicial Service Senior Branch, that is District Judges cadre, from the date the vacancy arose in that cadre, which in that case was subsequent to the respondent joining service as FTC and during his service as an FTC judge. In the instant case, however, this is not the distinction made. However, there were no separate rules for appointment to FTCs. They were promoted under the 1983 rules, as if they were being promoted to regular vacancies. But as the FTC scheme was a temporary scheme, can the contention of the promotees that their seniority have to be counted from the date of their appointment as an FTC judge be accepted? So even that part of Debabrata Das was considered by the division bench. Then Mahesh Chandra Verma, I'll skip, then A.K. Subram, Patvardhan, then Baleshwar Das, which lordships have seen earlier reference. May I then take your lordship straight away to para 74, just above which Debabrata Das is once again referred. The Honorable Supreme Court held that the respondent therein was entitled to count his service in the cadre of district judge from the date the vacancy arose in that cadre and not from the date when he joined the service as a judge of the FTC. Thus, what emerges from a consideration of the precedents on the issue is that the service rendered by the promotees in FTCs is not merely stopgap or fortuitous. No doubt their appointment was on an ad hoc basis. That was because the FTC scheme itself was not permanent. But too much negative emphasis on the expression ad hoc cannot be placed in the instant case. Because their lordships have considered in what context the FTC appointments took place to this honorable court, to the district judiciary of this honorable court. Even if the promotees were promoted as FTC judges on an ad hoc basis, their promotions were not on random or by any pick and choose method. Administrative committees of Committee 2 of this court considered the names of civil judges in order of seniority as well as on the basis of their individual merit, and recommendation was made by the committee to appoint them as FTC judges. Their suitability to work as FTC judges was based on seniority cum merit in terms of the 1983 rules. The 1983 rules did not prescribe any specific procedure for selecting the candidates by promotion, by seniority, come merit. Then, my lords, I'm skipping this in the interest of time and taking your lordships over the page 387, the conclusion therein, about 6 lines into the paragraph. The promotions were made after the establishment of FTC courts in the state to vacancies which existed in the cadre of district judges. The appointments were thus in a substantive capacity, although the posts were of a temporary nature, as the FTC scheme itself was a temporary scheme. Therefore, if the argument of the promotees is to be accepted, then relief would have to be given to the promotees by holding that they are entitled to count their seniority from the date they were promoted as FTC judges under various government orders, in which case the claim made by the promotees would be fully met. Over the page, my lords, once over, Debabrata Dash is referred. I need not trouble your lordships with that.
Now, this
Yes.
question often arises on the administrative side,
Yes, my lords.
wherein at the time of making promotions, we find that the number of persons who are entitled for promotion sometimes exceeds the vacancies. So what the administrative committee normally does is we only defer it, not because they were not entitled, but simply because posts are not
Are
there.
not available.
So this aspect as to whether there were vacancies as on that date and hence they were posted as fast track district judges is again we'll have to just look at the administrative committee proceedings.
Please.
And that appears to be the finding here.
The finding, and my lords, that I don't think either of us can make good. The High Court has filed before your lordships that material, both before the single judge and the division bench. Your lordships wanted an additional statement, which my esteemed friend Mr. Naganan submitted on the last occasion, is also there. And on those facts, again, I do not think there was really a difference of opinion before the two learned judges. I'll be taking my lords to the differing opinion to show what really weighed with his lordship there was this interpretation of whether a temporary post can be counted, and secondly, whether, my lords, the FTC issue was conclusively decided or not. If your lordships find that the question of FTC is conclusively decided in this judgment, the matter rests there. The High Court was a party to this. Of course, we were not parties, so I may be not able to argue, my lords, that inter parties there is a binding effect, regardless of change in the law. But as far as this honorable court is concerned, this judgment has been accepted. And there are third party rights involved, my lords. We cannot now unsettle all that. I will be showing how the direction of the differing opinion while dismissing the appeal is really to unscramble the egg with retroactive effect in respect of those who are appointed, my lords, to the FTCs who are not parties to the lists. It will, in fact, my lords, if I may say with some certainty, only create more litigation. So just to complete this, my lords, para 78.
At the end, after you conclude, we would also want you to demonstrate what would be the consequence. Let's assume
Please.
that we were to give effect to it.
Yes.
What would be the consequence, demonstrable consequence?
Please. Please. In the instant case, para 78, the appointment order uses the expression ad hoc because the FTC scheme was a temporary scheme, but by that logic, it cannot be stated that the service rendered by FTC judges was a stopgap service or for a specific or limited period only. Therefore, the service rendered by the FTC judges in the state would have to be counted for the purpose of giving weightage and for determination of their seniority, at least from the date the vacancy arose under 1983 as well as 2004 rules, if not from the date of their appointment as FTC judges. This would be in consonance with the dicta of the Honorable Supreme Court discussed above. On consideration of the judgments of the Honorable Supreme Court, what follows is that the date of confirmation to a post in the year 2009 in the instant case cannot be reckoned as the date for purpose of ascertaining seniority. In the instant case, the admitted position is that the direct recruits were appointed as probationary officers in 2008 and promotees were confirmed as district judges in June 2009. Notifications dated so and so have to relate back to the date on which the promotees could have been appointed in the vacancies. Then, There is also para 80 where the courts looks at it from a different angle. I need not, my lords, dwell on that. And finally, the answer at para 81. The questions raised by the learned single judge could be answered in the following manner: that the extant procedure in the matter of promotion to the post of district judge was followed while appointing the promotees as ad hoc district judges for the FTCs. Their promotions are in substance traceable to the 1983 rules. Vacancies that occurred prior to the enforcement of the 2004 rules have to be reckoned for giving deemed date of promotions from the date their vacancies arose, but not from the date of their promotions on ad hoc basis in 2003, 2004, nor from 2009 when the notifications were issued. That the district judges who were promoted by notification dated so and so to fill up under the rules would be entitled to the same benefits. I don't think I need to read the remaining portion, my lords, only to say that this question is settled in this judgment. Now, please see the view, my lords, the differing opinion. Where at paras 74, it is thus noticed. This your lordships get at page 130 of volume 1. Okay. Lordships have that, my lords. It is thus noticed.
Paragraph
74, my lords.
Single judge.
Please, no, my lords, of the differing opinion.
Separately there.
Internal page 130. Paragraph you refer.
Page?
Internal page 130.
That would be internal page 130, my lords. Grateful. Para 74, reference is made to Dinesh Kumar Gupta's case, which is a bench of 2 learned judges. I will show your lordships how this could not have been relied upon. It is thus noticed that the Honorable Supreme Court in the case of Dinesh Kumar Gupta has framed a specific issue in para 40.1, and it is held that judicial officers promoted on ad hoc basis as additional district and sessions judges to man the fast track courts in the state who were substantively appointed to the cadre of district judge are not entitled to count their seniority from the date of their initial ad hoc promotion. It is thus concluded by the Honorable Supreme Court in para 42 that the reckonable date has to be only the date when the substantive appointment is made and not from the date of the initial ad hoc appointment or promotion as first fast track court judges. The Honorable Supreme Court in the case of C. Yamini has categorically held that the service rendered by the FTC judges cannot be considered as regular judicial service for the purpose of 217(2) of the Constitution, since such service was not reckoned for the purpose of seniority, but would count only for pensionary and retirement benefits. Thus, the law is no longer res integra with regard to this issue. Not no longer res integra because of Brijmohan 1 and Debabrata Das. They are both judgments of 3 learned judges of the Honorable Supreme Court. Both those judgments were considered, my lords, in Dinesh Kumar Gupta in the context of Rule 247. Rule 47(3) of the Rajasthan rules to come to a certain conclusion. Lordships have seen every view on this point is rules specific. But on the treatment of FTC, the division bench of this honorable court considered the law on the point and came to a certain conclusion. But here his lordship is referring to Dinesh Gupta and holding that the issue is no longer res integra, as if that is the only and the last word on the point. Holding thereafter at 76 The fast track court judges can be assigned seniority only from the date on which they are substantively appointed as district judges and not from any anterior date. That is from the date of their ad hoc promotion as fast track court judges. The service rendered as fast track court judges cannot be considered as judicial service for the purpose of 217. Then, my lords, then the earlier division bench judgment is bad. Their lordships, my lords, spent paragraph after paragraph explaining why, despite the use of the word ad hoc, it was not to be treated as some casual or ad hoc appointment in that sense, because the scheme was temporary. But for all other purposes, the concomitants of service followed. Can that then be held to be, my lords, bad law? However, it is to be examined if the petitioners can be permitted to raise such a ground in view of the earlier decision of the coordinate bench of this court, as contended by the learned senior counsel appearing for the High Court. I have no hesitation to say that under Article 141 of the Constitution, the law laid down by the Honorable Supreme Court would prevail over earlier directions issued by the division bench. So, implying thereby that the division bench stands impliedly overruled by which judgment? And even if so, as far as the parties to that list are concerned, the judgment is binding. Can all that be unsettled, my lords? Can this be considered in a vacuum? Lordships asked me the hardship. This is the hardship. The contention of the petitioners that when the final seniority list of district judges annexure N was published on 16/3/2022, the High Court was bound to follow the law laid down by the Honorable Supreme.
Just one.
So sorry.
Yes.
Yes, exactly. So, my lords, I was reading 78. The contention, the middle of para 78, the contention of the petitioners that when the final seniority list of district judges was published on 6/3/22, the High Court was bound to follow the law laid down by the Honorable Supreme Court prevailing as on that day, and that an earlier division bench decision cannot be relied upon to the extent it is contrary to the ratio laid down by the Honorable Supreme Court is justified. So therefore, according to his lordship, the High Court on the administrative side should keep away the division bench judgment passed on the judicial side, to which it was a party, disregard it, then apply its mind as to what is the law on the day, interpret, my lords, Dinesh Kumar Gupta in a particular way, which is also erroneous, I will show your lordships, disregard the earlier larger bench judgments, and redo the exercise. It would invite a contempt petition. This is, I'm very sorry to say, my lord, this is the outcome of this view. It is well settled law, para 79, relating to precedents that an earlier ruling of a smaller bench stands overruled either expressly or by necessary implication when a subsequent larger bench or higher forum lays down the law to the contrary, though the earlier ruling of a smaller bench would bind the parties inter se. On both principles, the observation seems to be extraneous. Firstly, inter se, it binds. Secondly, my lords, the larger bench is that of Brijmohan, not of Gupta. In this case, neither the petitioners nor respondents 13 to 82 were even appointed as district judges when the decision was rendered to the coordinate bench on 3/4/2014, and none of them were parties to the said case. Further, the determination of seniority with regard to fast track court judges pursuant to the decision rendered by the coordinate bench of this court has never become final. The final seniority list published by the High Court in the year 2016 was withdrawn upon the basis of the report of the committee constituted on the administrative side of the High Court in 21, and thereafter the final seniority list dated 16/3/22, that is impugned, was published. It cannot therefore be said that the issue relating to assignment of seniority to fast track judges is settled or has become final. Is this not apparently wrong?
Now, the division bench judgment in the writ appeal was now has attained finality. There was no appeal.
No, my lords.
And pursuant to that, some decision was taken
On the administrative side. On the judicial side, the matter was final. Whether the list was once drawn, withdrawn, redrawn, etc., does not change, my lords, the binding nature of the judgment. And now please see the most interesting part, para 80. As discussed above, all fast track court judges have retired from service long back, and they would not be affected in any manner if their ranking in the seniority list are revised in consonance with the law declared by the Honorable Supreme Court. Please see this. Firstly, non-joinder is thrown to the winds. Secondly, the absurdity of the outcome that fast track judges who were party to the earlier division bench judgment, now at their back, must be subjected to a revision in their seniority basis the law declared by the Honorable Supreme Court, in which judgment they would always be entitled to count their service as fast track court judges for the purpose of protection of their pay and pensionary benefit. But what about their seniority? We don't know, my lords. Your lordships ask me what is the consequence. Then this is the exact unscrambling of the egg. That parties who are not before the court, parties who are subject to a binding decision, rules that have been interpreted, everything is at large with retroactive effect. Lords, that would never augur well. And here we are dealing with appointments made, my lords, under the supervision of this honorable court to the judicial service, where the need for certainty and finality is far greater. If this was applied, my lords, in any other department of the state, your lordships would come down on it with an iron fist, saying, you must draw the line somewhere. So they would always be entitled to count their service as fast track court judges for the purpose of protection of their pay and pensionary benefits. It is the duty of this court, which is also a constitutional court, to give effect to the law declared by the Honorable Supreme Court, especially where none of the parties to the earlier litigation would be affected in any manner, if the rankings in the seniority list are revised as per the law that existed when the final seniority list was published. How does the learned single judge, my lords, I ask myself, come to the conclusion that none of the parties would be affected? If none of the parties are being affected, why are we undertaking this exercise? It can never be an academic exercise. No, these are serious matters. The respondents, etc., are all up for promotion after hard-earned service. It has a direct bearing on their rights in their service, the potential for them to come to the bench before this honorable court. Can we then, my lords, undertake this kind of a roving expedition? Is the question, my lords. Certainly not. Your lordships would frown upon such an exercise. Thus, in the peculiar facts and circumstances of this case, I am of the opinion that the contention of the petitioners that the fast track court judges should be assigned seniority as per the law declared by the Honorable Supreme Court is tenable. Without addressing the question as to how the writ petitioners have shown any prejudice or violation of their right or their vested right to be considered for promotion, this finding is given. And thereafter, my lords, the learned judge goes into the granular
Just one.
lordships.
The list. You've already made submission. Say, none of the promotees are temporary or fast track judges. Last one. I think you have made a submission that none of the promotees are temporary or fast track court judges. So why are we going into that issue? Whether the promotion that is granted to the fast track court judges?
Because
No,
yes,
that is there, but none of them are that. That issue we need not dwell upon also. I think.
then, and the learned judge also ought not to have. It's
So,
because I'm so
factually,
great.
this aspect is clear.
Yes, my lord.
None of the judges are fast track court judges.
Quite so. It's because the records were called for before the division bench. Initially, my lords, the records were that annexure N. The more granular details were sought for by an interim order. I'll just place that. It will be in your lordship's file. By an interim order, before reserving the judgment, their lordships wanted to see the respective notifications against each of these posts. Once that was placed, his lordship has chosen to go into this question. The discussion, in fact, could have begun and ended with the larger question that was framed by her ladyship while deciding the appeal. Is the matter conclusively settled by the division bench? Is the temporary appointment to be covered under the definition of cadre or not? And first and foremost, what prejudice or right have the writ petitioners shown? And with that, the matter could have rested. I'm so grateful for this question because it shows, my lords, the unnecessary, if I may say so with respect, attention paid to all of this at the back of parties who are not here to lead to this roving expedition of redrawing a seniority list without taking into account, my lords, the spiraling implications that it would have. And that your lordships find para 83 onwards, his lordship has gone into these issues. In fact, to answer my lady's question, para 86.
Before that, I think we can see 82 also.
Please, I'm so grateful. In view of the aforesaid declaration, 82 senior civil judges who were promoted on ad hoc basis as district judges to man the fast track courts by notifications dated so and substantively appointed as district judges on 1/6/2009 cannot be given seniority prior to the date of their substantive appointment. As could be seen from the final seniority list, the fast track court judges at serial number so cannot be assigned seniority from 26/5/2003 to 1/1/2009, and their seniority will have to be reckoned from the date of their substantive appointment as district judges on so. In such an event, there will be a cascading effect, and the subsequent promotees within the 65% promotional quota will be further pushed down. That is asked notes. On this ground alone, the seniority list is required to be redrawn by the High Court. It is only when the seniority list is redrawn one can exactly ascertain if any of the respondents would also be pushed down in the rankings assigned in the seniority list as a consequence. So this finding is in fact in contradistinction to the earlier finding that there would be no prejudicial effect. Is this not, my lords, an indictment or at least a stricture on the seniority of all these persons? Then they should have been arrayed as parties. I'm so grateful, my lords, to the bench for highlighting this paragraph. This is exactly, my lords, the unwelcome outcome of the directions issued. And the question, my lords, as to how this material came, para 86 was the memo of the High Court. The High Court has filed a memo dated 8/9/2025 providing the details relating to increase in cadre strength of district judges from 1/5/2003, which is anterior, my lords, to the appointment of the writ petitioners, to 21/1/2016, along with certain notifications, government orders, letters. However, the petitioners have filed objections to the said memo on 10/9/25, contending that 32 posts mentioned by the High Court cannot be considered as part of the cadre strength. This is how the issue arose. The said contention needs to be examined. Lordships may consider whether it actually needed to be examined. Even if, my lords, petitioners filed some objection to that at this stage, when the memo came on 8/9/25, the question really could not have been gone into and reopened. And thereafter, the entire reasoning, lords, is on that, one by one. I won't read all, just to show your lordships. Notification dated 15/2/2002, serial number 1, relates to a court created for the purpose of trial relating to the Dandupalya gang. Another notification relates to a court created for the purpose of conducting trial relating to fake stamp papers. As per the notification, condition 1 stipulates that the post was created only for a period of 1 year and prior approval is mandatory for continuation of the said court. This has been considered, that though the schemes may have been temporary because of the peculiar need, these were some special cases, my lord, Jayalalitha's case later, then my lord, stamp paper, I think the Telgi case, etc. They may have been time bound, but the division bench considered that none of this changes the nature of their appointment and their right, my lords, to be considered when a substantive vacancy arises. One could never have gone into this. And this continues, the Lordship should find throughout, I won't read, the entire remainder of the judgment, para 88, is with respect to one particular appointment on deputation, then additional, contrary to Ganesh law, that's right. And all the way, my lords, even deputational posts have been held to be not counted. That's the entire, my lords, judgment thereafter. Temporary post question. I'm so sorry. Just briefly. Where is that? See, also in the context of 217, no? Because of the rules.
In other rule also, there is no exclusion in Ganesh case. That was a thing we were thinking earlier also. Paragraph number 18. This is all with regard to all that ad hoc courts.
So far as the para 86, there's a reference to the 32 posts.
Yes.
Which is objected to by them.
Please.
How will the list look if that is excluded? Will it have an implication? Just reflect upon it so at the end you can show us.
Very good. And in fact, the High Court may be slightly better placed to answer that question. I will also in rejoinder meet these two queries from your lordships.
One of the contention.
They have modified reply and they only High Court can get it, can say.
One of the contentions raised by the petitioners was that even if, I mean, by Mr. Rajgopal, is that even if we were to accept that there is a discrepancy, it would not impact.
Yes, and I think he tried to make that good empirically. Yes. I would adopt that, my lords.
So that only for the purpose of clarity.
Yes, my lords.
If it could be demonstrated by the High Court, as you say, who is more competent, to show that even if this is to be done, but if the material on record would show that, you could demonstrate.
I'll do that. So, my lords, I will conclude my submissions now by just briefly referring to the.
Can you please read the paragraph number 89?
89, I'll do so. It is claimed that as per notification dated 31/10/91, there was increase in cadre strength of one post of district judge. The note appended on page 4 of the memo would show that the said post was considered as part of the cadre strength of district judges from 1/8/2005, as a judicial officer was posted to the said post for the first time. However, reading of the notification reveals that it relates to the amendment to the High Court of Karnataka Service Rules 1973, whereby the nomenclature of additional registrars is substituted by Registrar Judicial and Registrar Administration. The notification does not relate to creation of post or increase in cadre strength of the district judges. Even otherwise, as per the method of recruitment prescribed under the recruitment rules relating to the said post, they can only be filled by promotion from the post of the deputy registrar or filled by posting a person who has been a district judge. Though the post is validly created on the establishment of the High Court, the said post need not be mandatorily filled up by a serving district judge, There is also no notification issued by the state government with concurrence of the finance department for making this post as part of this cadre strength of the district judges. Thus, this post also cannot be considered to have been made part of the cadre strength.
Does this amount to creation of a post? That is,
I have frankly, my lords, not applied myself to this one post because the aspect of the notification of the state government, I think the law is well settled. 233, those are not aspects that can vitiate the creation of the post. But keeping that apart,
now whoever are working as a district judge, already there is a post, they'll be coming and working on in the High Court.
please,
So whether it amounts to creating a post, it will add to the cadistrict.
please.
Just 1 minute. Constitution.
As far as establishment of courts and appointment of judges, that stands on a different footing.
Quite so.
What about these posts?
Where on the administrative side, they are appointed as registrars.
That's all. I think the argument was last time. About this.
That appointment, a vacancy is created. But by what?
Constitution scheme sets that the High Court must have primacy. The power of appointment is by the High Court and only governor gives sanction. So, other rights also, High Court should remain a larger now, insofar as your argument of 233,
Yes.
are you saying that though 233 deals with appointments, the primacy of the High Court cannot be undermined even with respect to service? That's your contention.
Quite so. And that's the view, my lords. Bal Mukund Shah has settled that question.
Can we have a look at that?
I'll take a lot. On this, my lords, this pertains to one, my lady's question. This is in respect of one post. I don't know how much difference it would make to the larger picture. But as my colleague was mentioning, my lords, on such deputation, then a corresponding vacancy would arise in the court. And maybe that is what has weighed with the High Court while considering this also as part of the cadre. That could be one aspect.
This is exactly what we do. District judge is come, deputation to the High Court. Are we going to bring that post? Are we going to answer to appointing somebody wherever the vacancy is? Who will decide? So, these also.
From where are you drawing these people? Are you drawing it from the lower cadre or the existing cadre?
That's what the question is. High Court has.
High Court will also have to touch upon, which you could touch upon the question. Now, suppose there are some vacancies or creation of additional places where you have to fill in people. Are you drawing them from the lower cadre or the existing cadre? Is something which will be a part of the administrative committee proceedings, etc., which they have to demonstrate. Now, let's assume that Lokayukta says we want 4 judges to man these posts. So, from where are you drawing? Are you drawing them from the existing strength, or you are creating an additional so that when they come and then after the term ends, they go
revert.
back or they go horizontally to some other?
They revert, then, my lords, question of lien and so on also arises. Often, even under the Universities Act, in such circumstances, the lien is retained. I quite see, my lords.
That's only a factual aspect though, but I think the High Court may have to place those administrative committee proceedings unless there is some, uh, so that the factual aspect is clear.
Please.
Yes,
But your lordship wanted to see Balmukansha.
yes.
And of course, my friend has more than once submitted that we cannot raise this because we did not file a reply in the writ.
No,
I think much water has flowed since then.
no, that apart, we are not looking at is a inter partes list. We'll look into
Yes,
the rights, no doubt, but we are looking at it little with a broader perspective.
Of course, my lords, it is that kind of question. And we are here to assist your lordships. Now, if just on a technical objection that my friend has raised, if I have not filed an objection, it does not preclude me from preferring a writ appeal. I filed the appeal. There was,
I'm not saying that. I'm only they can answer the particular law, not on facts, not on facts. But they what find it right.
Yes,
please, yeah, I'm sorry, I have only 2 copies.
that's
lords.
it.
Please pardon us. The court officer could take out the SEC.
Yes, yes.
Yeah, grateful. Balmukul sir, 1 nimsha sir.
2000 volume 4 SEC 640.
640 Constitution Bench judgment. I had in fact referred to this in my note as well. Paras 30, 31 and 35 minutes.
30.
30, 31 and 35. Isn't it? That your lordships get at internal page 679.
682.
682. I'm grateful. Para 30. It has also to be kept in view that neither Article 233 nor 234 contains any provision of being subject to any enactment by the appropriate legislature, as we find in Articles 98, 146, 148, 187, 229, and 324(5). These latter articles contain provisions regarding the rule-making power of the authorities concerned subject to the provisions of law made by Parliament or legislature. Such a provision is conspicuously absent in Articles 233 and 234 of the Constitution. Therefore, it is not possible to agree with the contention of the Learned Counsel for the Appellant State that these articles deal only with the rule-making power of the governor, but do not touch the legislative power of the competent legislature. It has to be kept in view that once the Constitution provides a complete code for regulating recruitment and appointment to the district judiciary and to the subordinate judiciary, it gets insulated from the interference of any outside agency. We have to keep in view the scheme of the Constitution and its basic framework that the executive has to be separated from the judiciary. Hence, the general sweep of Article 309 has to be read subject to this complete code regarding appointment of district judges and judges in the subordinate judiciary. In this connection, we have also to keep in view Article 245, which in its express terms is made subject to other provisions of the Constitution, which would include 233 and 234. Consequently, as these twin articles cover the entire field regarding recruitment and appointment of district judges and judges of the subordinate judiciary at the base level pro tanto, and otherwise paramount legislative power of the state legislature to operate in this field clearly gets excluded by the constitutional scheme itself. Thus, both Articles 309 and 245 will have to be read subject to Articles 233 and 234 as provided in the former articles themselves. And finally, my lords, at 35, after considering
Just 1 minute. Whether that could be extended.
Yeah, it is that conspicuously it is absent.
So there is 233
Rulemaking.
and 233 also appointment. So recruitment of the service master. Yes.
Please, Lords. 35, if your lordship see, in order to fructify this constitutional intention of preserving the independence of the judiciary and for fructifying this basic requirement, the process of recruitment and appointment to the district judiciary with which we are concerned in the present case is insulated from outside legislative interference by constitution makers by enacting a complete code for that purpose as laid down in Article 233 and 234. Consultation with the High Court is therefore an inevitable essential feature of the exercise contemplated under these two articles. If any outside independent interference was envisaged by them, nothing prevented the founding fathers from making Articles 233 and 234 subject to the law enacted by the legislature of states or parliament as was done in the case of other articles as seen earlier. That, my lords, would answer the question. And it is in keeping, my lords, with Article 50, which is the directive principle regarding separation of the judiciary from the executive.
Come to para 34.
34, my lords.
Yes.
Very good. It also has to be kept in view that judicial independence is the very essence and basic structure of the Constitution. We may also usefully refer to the latest decision of the Constitution bench in Registrar versus Satpathy, wherein Justice Venkateswamy, speaking for the Constitution bench, made the following pertinent observations in the very first two paras regarding Articles 233 to 235 of the Constitution. An independent judiciary is one of the basic features of the Constitution of the Republic. The Constitution has zealously guarded independence of judiciary. Independence of the judiciary is doubtless a basic structure of the Constitution, but the said concept of independence has to be confined within the four corners of the Constitution and cannot go beyond the Constitution. The Constitution bench in the aforesaid decision also relied upon the observations of this court in All India Judges, wherein on the topic of regulating the service conditions of the judiciary as permitted by Article 235, read with 309, it has been observed as under. The mere fact that Article 309 gives power to the executive and legislature to prescribe the service conditions of the judiciary does not mean that the judiciary should have no say in the matter. It would be against the spirit of the Constitution to deny any role to the judiciary in that behalf, for theoretically it would not be impossible for the executive or the legislature to turn and twist the tail of the judiciary by using the said power. Such a consequence would be against one of the seminal mandates of the Constitution, namely, to maintain the independence of the judiciary. In view of this settled legal position, therefore, even while operating in the permissible field of regulating other conditions of service of already recruited judicial officers by exercising power under 309, the authorities concerned have to keep in view the opinion of the High Court of the state concerned. The same cannot be whisked away.
Yes.
Please. And Article 50, my lords, the directive principle for separation of the judiciary from the executive is really what has weighed with the court. Lords, I will conclude by just referring to that judgment in Gupta's case, because the learned differing judge has made reference to that as if to suggest that is the law of the land on the point. Court of I need not dwell much on this, my lords, except to show that at para 2.4, make an index. Para 2.4, my lords, Brij Mohan Lal 1 is referred, which, as I pointed out, is of 3 learned judges and followed by the division bench of this court. Soon thereafter, in its decision rendered on 6/5/2002, in Brij Mohan Lal, this court had an occasion to consider the issue relating to FTCs. The 11th Finance Commission had allocated rupees 502.90 crores for the purpose of setting up 1734 courts in various states to deal with long pending cases, particularly sessions cases. On the basis of the said recommendations, a note was prepared by the Department of Justice to set up FTCs. Challenges were raised in some high courts to the constitution of such FTCs, and the matters were dealt with by this court in transfer petitions. After considering the rival submissions, directions were issued in para 10, and for the present purposes, directions 1 to 8, 14 and 18 are relevant in Brij Mohan. Please only see direction 14 over the page, my lords. No right will be conferred on judicial officers in service for claiming any regular promotion on the basis of his or her appointment on ad hoc basis under the scheme. The service rendered in fast track courts will be deemed as service rendered in the parent cadre. In case any judicial officer is promoted to a higher grade in the parent cadre during his tenure in FTC, the service rendered in the FTC will be deemed to be service in such higher grade. So the matter ends there. It so happens on the interpretation of Rule 47 of the Rajasthan rules, which your lordships find at, yes, at page 629 on the question of seniority, a rule peculiar to Rajasthan, 47.3, my lords. Seniority of persons appointed to the service in the district judge cadre by direct recruitment shall be determined from the date of the order of substantive appointment in the cadre. This is what was being considered, and the ratio at para 52 only holds, yes, 52 at 667 holds that it is true that as on date, when the 2010 rules came into effect, there were 83 fast track courts functioning in the state, and appropriate mention to that effect was made in Part A of Schedule 2 to the 2010 rules. It is also correct to say that the ad hoc promotions granted to the judicial officers considered were under the 1989 rules. But such promotions were on ad hoc basis to man the fast track courts, and the law on the point is now well settled that the service rendered by such officers as fast track court judges on ad hoc basis cannot be taken into account while reckoning seniority after such judicial officers were granted promotions on substantive basis, and that their seniority has to be reckoned only from the date of their substantive appointment to the cadre of district judge. This said 1969 rules do not in any way confer any right which would be inconsistent with the law so laid down by this court. It's a different proposition, my lords. What the effect of the ad hoc appointments in Karnataka is concerned has been settled by the division bench, holding that though the phrase used is ad hoc, it is not to be treated as such. And the simple question was, when the substantive vacancy arises, can the consequence follow in terms of, my lords, the appointment to be made? Now, it seems that his lordship has treated this as being the last word. It cannot. This is two learned judges. It's on a different point. This judgment refers to Brijmohan 1 and Debabrata Das. Lordships may just refer para 41. Debabrata Das, which is of 3 judges, has been recognized. And lordships, being conscious of that, held in the context, para 41, Debabrata Das, I have already read it. Being conscious of that, while interpreting 47.3, came to a certain conclusion. In fact, it is in harmony with what has already been laid down, and could not then be treated as the basis for some implied overruling of the division bench, so as to, my lords, redo the entire exercise. And I have filed before your lordships. I'll just, my lords, read one rule again to your lordships and close. Where is that? This is the 2004. The 2004 rules also, which is at page 704 of your lordship's papers.
704. Page 704.
His total posts.
Third volume. Fourth.
These rules, my lords, at 704 are the 2004 rules which replace the 1983 rules. Made in exercise of powers under 233, 234 and proviso to 309. kindly come to 4, method of recruitment, qualification, etc. In respect of each cadre of posts specified in column 2 of the table below, the method of recruitment and minimum qualification, age limit, etc. shall be as specified in the corresponding entries of columns 3 and 4. For district judges, please just note these words: 65% of the total posts in the cadre shall be filled by promotion from the cadre of senior civil judge on the basis of seniority cum merit. So her ladyship, while allowing the appeals, notes rule 4 of the 2004 rules alongside the other rules that I had read to my lords. I have also filed, my lords, as directed, a preliminary written submission, which was filed, my lords, on 11/12/2025. I won't trouble your lordships with it because it is, my lords, a capsule of what I have submitted before your lordships, and perhaps at the concluding stage, we may be permitted to file, my lords, a supplementary note of submissions. I'm so deeply obliged, my lords, for a very patient hearing in this matter. So grateful.
Yes.
The next date is what we find convenient. What we find convenient
Please.
is on Monday, because in that week, the Friday, Friday there may be some. So Monday. 19th.
Senior,
19th. Huh?
senior, sorry, my lord, senior is unwell. Tuesday or Wednesday, need it. And also a chart was, court directed us to file a chart, which is getting ready. Lordship will file it on
Middle of
Tuesday.
Middle of the week.
Thursday. Friday is a half day. So Thursday. It's the half Monday.
Okay.
Because we have to go back. Good. 23rd morning, we have to check it because it's in written there. He has to ask for that. It's a building of Thursday. Next week is coming. We have to get it. 26, 27, 28, 29, 30th, Tuesday, Saturday, half day.
Okay. 30, 31st,
Any of it. So instead of this two, we can add that afternoon every day. Instead of having anything next week, it is convenient to go for us. 28, 29, 30, and 31st. 4 consecutive days will complete afternoon session. People let know, sir.
29 and 30 and 31 okay. 30 and 31.
That is any of it. This one of the feature of
Inform. We'll see which day we'll inform. 30 and 31 tentatively you mark it in your diaries.
Afternoon.
30 and 31.
31st is a sitting day.
Yes. 30 and 31 you mark.
2:30.
Which other day we will see.
Yes, ma'am.
The arguments of learned senior counsel Shri Aditya Sondi is concluded. This is the matter for further hearing on a date to be fixed.
So and so.
Date to be fixed by the
Court of service.